Welcome to the channel. If your first time joining, for return, thank you for coming back. Yes, I know it's been a long time. It's been a minute, man, and so much has happened, but we got some great news. Waiver of sovereign immunity for Henry County and several defendants in that case. The case was for Henry County was dismissed. The judge set the order in for that, but then it was a motion to set aside judgment. Before I get ahead of myself, make sure you hit that like and subscribe button. It helps the algorithm grow, helps the channel grow, all that good stuff like that. If you've been with the channel for a while, man, thank you. Your support means a lot. Man, we got a lot of ground to cover. I'm gonna try to condense it and make it as short as possible, but yeah, mainly we're going to talk about this waiver of sovereign immunity, man. This is big and great news, you know, and it's all about doing your doing your due diligence and research, and it'll take you a long way. So let's go ahead and jump off into it. If you don't have an account with Peach Court, I encourage you to start one. That way you can follow along with the case. That's the case number right here, or you can look it up by name. Okay, let's go on down to this order to dismiss the case 80, and these are called minute entry numbers, or each one of these is called a minute entry, but you're going to go to number 80, right? And that'll be the final order. So in that final order, the court finds that the action should be dismissed for the grounds detailed in the defendant's motion. This was a bad day for the plaintiff, right? So pretty much in their motion, they kind of laid out the background and said this pro se action concerns the plaintiff's displeasure with his incarceration and the events that took place in that context and response to his open records request. This is an important part right here. All right. The plaintiff claims false imprisonment, cruelty to inmates, tampering with evidence, violation of detention officer's oath of office, violation of the Open Records Act by defendant Brown, and the claim of liability of insurance, Henry County Insurance. They meant to say county, but he typo. All right, and so let me explain something to you right here. Okay, let me make this explicitly clear because I don't want you to make the same mistake. If you are suing or want to sue can't even get out right. If you want to sue a sheriff's department or the employees there, you need to name the sheriff of that county or of that jail, or whatever the case may be. Pretty much, yeah, the sheriff of that county, because they're elected official. They are responsible for the conduct of their of his or her employees. You have to name them as a defendant. If you name the jail, like if you put Henry County jail or sheriff's office, it is not a legal entity that can be sued. So I just want to make that explicitly clear because the case will get dismissed. Okay. Let's move on down to defendant Brown, right? And then we'll go back to the waiver of sovereign immunity for the county, but this pretty much helps in doing that. So defendant Brown pretty much messed up. She messed up so bad and so many times. So in their motion, they put defendant Brown is a public officer sued for her work at Henry County Sheriff's Office. Official immunity bars all claims against defendant Brown, who carried out a discretionary function for responding to the plaintiff's open record request. This is wrong. The open records request is not a discretionary function. This is a ministerial function. This means it's a duty. You have to do it. There's no room for discretion when doing that. You could do more research on that, but look up ministerial function, it's ministerial function with the open records request. So that right there is bogus, and they did that to throw the plaintiff off. So moving right along, so you got several options. You can do a motion for reconsideration, you can do a motion to set aside judgment, or you can appeal the case, right? So in this motion for reconsideration, it touched bases on the violations of the Open Records Act. Now let's look at the law. We're going to scroll down. Let's go over here. Where are we at? Okay. Oh, here we go. So, and this is the code that you can look up. This is for the Open Records Act and what it's for and how it needs to be adhered to. So, agency shall produce inspection of all records in response to the request within a reasonable amount of time, not to exceed 3 business days. So that means after 3 business days, you're hit. If they don't have a written something written and saying why they can't respond to you in 3 business days, like they have to prepare it and stuff like that, if they don't do that, then they're so hit. A receipt of request. Provided, however, that nothing in this chapter shall require agencies to produce records in response to requests if such records did not exist at the time of the request. So pretty much if it's not there, they can't give you something they don't have, which is reasonable, right? So now in the whole thing is making, where's that? Making this Open Record Act. This is all supposed to be for transparency for your government, right? And this is pretty much a legislative intent and definition. The General Assembly finds it and declares it a strong public policy of the state in favor of open government, meaning that transparency thing, that open government is essential to free, open, democratic society, and that the public access to public records should be encouraged to foster confidence in the government so that the public can evaluate expenditure of public funds and efficiency of proper function of its institutions. Bam. Simple, right? They're trying to have transparency, and they made a law for it. So if you have somebody you're requesting information from and they don't give it to you, they are breaking the law, right? So let's go into this waiver and how it could be waived, right? So this is the Georgia Constitution. This actually got set into place on January 2021, where their sovereign immunity can be waived. So let's go ahead and check this out. This is the Georgia State Constitution. That's the article and subsection, all stuff like that. So you can look it up yourself. So sovereign immunity is hereby waived at the action of Superior Court seeking declaratory relief. So declaratory relief is pretty much saying that you want them to do or not do something, right? From state actions of, check this out now, of the state of any agency, that means anybody, authority, branch, board, bureau, commission, department, office, or public corporation of this state or officer, employee thereof of any county. That's the greatest thing right there. Any county, consolidated government, or municipality of the state or officer or employee thereof outside the scope of lawful authority in violation of the laws of the Constitution of the state or the Constitution of the United States. Sovereign immunity is further waived so that the court awarding declaratory relief pursue this paragraph may only after awarding declaratory relief enjoy such actions to enforce its judgment. Such waiver of sovereign immunity as under this paragraph shall apply to past, current, and prospective acts which occurred on or after January 1st, 2021. So if it happened before that, kind of messed up. But that's it right there in the law. That's it. This is it. This is the golden ticket right there. And furthermore, in the Georgia Court of Appeals, we agree that Gardner was in error, and so we reversed the order dismissing the action in its entirety. And on remand, the trial court may be determined that Gardner's claims against the county, if any, are subject to waiver of sovereign immunity in the Open Records Act. Then we're gonna go through the case, but pretty much it was the Open Record Act violations, right? There it goes. Okay. Gardner brought this action under the Georgia Open Records Act, seeking among other things declaratory relief, injunctive relief against Clayton County. Right? Bam. And they dismissed her case, but she sent it to the Court of Appeals and they remanded it back. Then they sent it back to the lower court where the case started from, right? Furthermore, in the Open Records Act, what could be done or where it could be handled at. The Superior Court of this state shall have jurisdiction in law and equity to entertain actions against persons or agencies having custody of the open records. Check this out now. Having custody of the open records to the public under this article to enforce compliance and provisions of this such article. Such action may be brought by any person, firm, corporation, or other entity. In addition, the Attorney General shall have the authority to bring such actions to his or her discretion as it may be appropriate to enforce compliance with this article, to seek civil or criminal penalties, or both. Golden ticket right there, baby. Okay, so we had to lay down a foundation dealing with the legal aspect of the Open Records Act. Now, Defendant Brown, and I'm so happy this woman did this, the first thing she did wrong was she didn't respond within 3 business days. Right there, that waived sovereign immunity. It's just showing that through filing motions, which should have been in the complaint initially, which actually it was, but in this motion to set aside judgment, that and showing that to the court, hey, look, this waiver sovereign immunity for the county, and it's real hard, and it's how can I put it? Let me start over. Hold up. 3 business days. She messed up right there. Then further, she ignored inquiries into that request and why it hasn't been answered. Then they kept giving the plaintiff, who was defendant at the time, blank disc, a copy of somebody, another defendant, or excuse me, another inmate. Somebody was getting booked at the Henry County Jail. Then when they finally did respond to it and was like, oh well, you know, the copies that you did, the request that your original request is the time is lapsed and 30 days is lapsed, so you can't get it. You know, the footage got deleted. So didn't respond within 3 days. Prolonged and aggravated. What's the word? No, it's pretty much prolonged access to the records, right? Then gave bogus copies, blank disc, and you know, blank footage or just nothing, and then said it's just not there anymore. Right? So that's called presumption. So if you're a plaintiff and you file a suit and you're stating that certain things took place, and these people that are in control of this information erase it or destroy it, then that's a whole nother charge in itself. And then that's when it turns criminal. But let's look at the paperwork and stuff like that. And all this stuff is on Peach Court. But man, it's just so crazy because now what that does, it allows the case to be revived, which is a great thing, because all the claims that's in that complaint was dealing with Henry County Jail and the things that these officers and a whole bunch of other staff did. And this is just, it's awesome. But the main problem right now is that with all of these cases, they keep ducking service, bro. If they were wrong, if they were right and they did nothing wrong, right? Why don't you just take it to court? Because guess what? If the plaintiff lose and it goes to trial and all that stuff, let it lose, then the plaintiff will have to pay attorney fees and all that stuff like that. It would be more expensive for the plaintiff. But the plaintiff is right. So that's just crazy. But anyway, let's look at the paperwork. Just so we can clear this up. So this is the law right here, 50/18/96, retention of video recordings for law enforcement sources. Law enforcement sources, keyword. Destruction, presumption of destruction, fee or for duplication, right? So, B. The recordings from law enforcement body-worn camera devices located inside law enforcement vehicles should be retained for 180 days from the date of such recording, except, right? Check this out. If such recording is a part of a criminal investigation, shows a vehicular accident, shows the detainment or arrest of an individual, look, checks out, shows the law enforcement using force. That's a key word right there. Key phrase. It should be retained for 30 months from the date of such recording, and if such recording contains evidence that can be reasonably anticipated to be necessary for a pending litigation, it shall be retained for 30 months from the date with such recording. And if the litigation commences during such period, it shall be retained until the final adjudication of such litigation. Not 30 days, 30 months, bro. 30 months. So from the day that the open record request was made for that footage, it should have been held for 30 months, bro. So that violates this right here. As quickly as possible because this is a lot to cover. So pretty much this was the original request. It was made on 16th 2023, right? I would like to obtain footage from the fingerprint station. I was taken to the fingerprint station 3 times. I want the full video from the night of the intake into Henry County Jail on that date and all the way through the night of release. Also the cost of the footage and full incarceration, from the full incarceration to release. All footage from every pod, every movement, and any reports made during my stay. Also all medical records and any reason for being put on suicide watch. Please respond to this email and let me know that you received it. Thank you for your time concerning this matter. Then they was like, contact WellPath. Now WellPath, this They're like the healthcare provider within that jail. They got a lawsuit against the borough. They're in bankruptcy court right now. You can look them up on your own time. They are so screwed. They didn't had so many issues with them. It's crazy.
The healthcare provider that worked inside the Mecklenburg County jails for years filed for bankruptcy, halting all lawsuits against it. Nashville-based WellPath ended its contract in Mecklenburg this year. Last week, it filed for bankruptcy. The healthcare provider is named in over 1,000 federal lawsuits across the country. CNN investigation revealed the company is accused of contributing to at least 70 deaths in 2019. In Charlotte, it is a defendant in at least 5 open lawsuits. Let's go ahead and bring in Chief Legal Analyst Khalif Rhodes to talk about this further. Khalif, the company is filing for bankruptcy. It's going to allow it to restructure here, but also could this shield it from the future lawsuits that it's facing right now?
Excellent question. You got to think about it. As you mentioned, in open 1,000 lawsuits across the country, 5 right here in North Carolina federal court. This strategy is something that is not new, even though it seems like it's new, seems like it's a great, new shiny toy to play with. In the legal world, this has been out there for a while. Late 80s, you had the asbestos lawsuits that were settled during this same type of process, then followed by the breast implants with Dow Corning, Sandy Hook in 2011 with Remington. Most companies that are facing a number of lawsuits from different angles will go this one. Look at the most recent one, Purdue Pharma, Sackler family. That was another Chapter 11 bankruptcy attempting to shield litigation, figuring out how can I avoid not only my company assets, but my personal assets being connected to this court, put the halt on that one. But in this case right here, I think it will have implications into how you move forward with a lawsuit against the company while in the process of being in bankruptcy.
And certainly.
Okay, now dealing with WellPath, I have to get off the topic real quick, but it's not really off topic, but dealing with them, this particular defendant that could have been named, they avoided a suit because they're in bankruptcy court. Now, in the complaint, the plaintiff states that they were placed in suicide watch. Mind you, all this started from tickets and a false arrest, bro. Citations, not even a misdemeanor charge or felony. This is tickets, something that you get, like, it's so petty, it's like a littering ticket. And it was just, anyway, and ended up putting the defendant on suicide watch because they exercised their Fifth Amendment right to remain silent. And they didn't like that. When you know your rights and stuff like that, and you deal with these people, they go ham, bro. They just start. They'll beat you up. They'll do wild stuff. You know what I'm saying? They'll throw away your property. Let's say you get locked up your clothes. You got to leave out with some clothes from the lost and found box. They do wild stuff, bro. I promise you. If you have your phone on you, they'll break it. Oh, it got damaged. All type of shit. Anyway, let's keep moving. So, where's that? Because it's so much going on, right? Let's go back up to, let me see. All right, so this is boom. So this is when they responded. This is longer than 3 days. That's longer than 3 days right there. Right? Let me see. Total estimate. Where's it at? Oh, it was $1,300. I thought it was $3,000. $1,300. All right, that's not bad. $1,300. That's three messed me up. It's $1,300. All right. Seeking a request for prepayment, estimate cost of $500 or more. So yeah, if it was over $500, then yeah, you got to pay for it or something like that. All right, the request to record the copy after received. The check of money orders had 30. Drop it off down there. This is on the 22nd, right? I think after some conversation with her fellow employees, they realized that that was not be a good idea. Okay, this is the first pickup. After reviewing the footage was given per my request, it was clear the individual was not me. I came intake on October, and I would like the proper footage. Right? No response. So let me see. Is there any issue? So it goes on. It's like no response. Checking up on the stats. Now, mind you, look, this is December. It's after the holidays and stuff like that. December. Let's go back. Where's that? Once again, my request. Look, this is December 21st, bro. Still ain't, bro. It just goes on and on and on and on and on. Right? And then it was like, yeah, you can file a complaint with Internal Affairs. Right? Where's it at? Is it, bro? It's a bunch of madness. It's so much. Oh, here it goes. All right. So boom. Erase this so you see it clear. So You received the wrong footage. Look at this. You received. Damn, this thing is too. I'm sorry, you guys. I'm sorry. Give me a second. Let me just go with the highlighter. You received the wrong footage on your original quest. However, once it was brought to her attention that 30 days has expired and original footage no longer available. If you want to speak to someone, you can speak with the jail commander, Colonel Daniels, right? And then after that, I believe this is when where's it at? Hold on, give me a second. Oh, boom. This is internal affairs. Central Internal Affairs, right? Bro, this man, where is it at? Cap Newton, this dude. I'm talking about come speak in person, bro. It's all right there in the email. And it says it, bro. At this stage, I still haven't received my original request. So that is 3 times over the course of 3 months. Clearly, Henry County Detention Officer in charge of retrieving this footage. I was informed by Miss Brown that she has no control over the request given over what is given upon request. I would like my overwork request to be completed, as well as an investigation into the incident that took place at Henry County Jail. Bro, and then he's talking about come down there, let's talk. Bro, we ain't got nothing to talk about. Bro, cough it up. Bro, it is so much. It is so much crap. And this is just an open records request. This is just to retrieve the footage to show what these folks did down there at the jail. And it just disappeared. And guess what? The city of Hampton did the same thing. Whenever as soon as the plaintiff was released, requested the body camera footage that I arrested off of that incident. Bro, all that shit was edited, chopped, and screwed. They did some AI stuff to it. It was crazy. They answered that after a year, bro. Oh, bro, it was crazy. All this is filed. You can go look all this stuff up on Peach Court. Even in arresting officers incident report, he said that his body camera was activated down there at the jail. So if they didn't have the footage of it down at the jail, he should have it on his body camera. That shit disappeared. Excuse my language. Everything just started disappearing. So you can't tell me that's a conspiracy, bro. And it's like this, bro. You know, this is really an insurance policy, because if something pop off, you can't say that somebody was like, here, look, I'm trying to show you guys this is how corrupt these guys are. They just do whatever. Family's involved. Friends are involved. It's crazy. Co-workers are involved. Everywhere you go, anybody, bro. There's so many people trying, bro. It is it is insane. This is completely insane. It's extremely frustrating, but that sovereign immunity is waived just from the Open Records Act, and they did it multiple times, many times. And this is where it gets really juicy. That is summary judgment. Those 2 words right there sound so good. Y'all have no idea, because there will be no trial.
Sometimes we've just seen enough to make a judgment. Same goes for court. A summary judgment is when a civil court rules in favor of one party over the other without a full trial. Now, this may sound like it's all willy-nilly, that maybe the court has a long weekend in mind. But a summary judgment is sought out by one of the parties. When a party files a motion for summary judgment, they are then referred to as the moving party. There are a few reasons a summary judgment may be issued by a court, besides the moving party just, well, wanting them to. There are 2 main requirements. First, the parties to the lawsuit have to agree on the material facts, the facts that are important to the legal decision. Second, the law must say these undisputed facts entitle the moving party to a judgment.
Okay, so now that we covered all that, now this is really good, because now that opens up the door for Henry County to be brought back into the suit and for the case to be revived again. And excuse me, all of the things that took place, it waived sovereign immunity for Henry County, not only just for the Open Records Act, but it opens the door for everything else. And if you could show the mistake that was made with dealing with the Henry County Sheriff's Office, their staff and stuff like that, was naming this Henry County Sheriff's Office as a defendant. It was not right. It was supposed to be the sheriff of that county in order to prosecute, in order to file a suit against the employees and stuff like that. This is just so crazy because, you know, you would think that, you know, you can get help from an attorney or something like that. Nah, bro, they all be paid off. It's all a big conspiracy. It's all crazy. The more stuff that they do to try to cover it up, it's just opening up the door for more of a lawsuit, or a bigger lawsuit. Remember a previous video where Henry County Board of Commission, when it was trying to get the insurance policy, and they wouldn't give it up. That's another lawsuit right there, and that's another waiver of sovereign immunity, because it was filed for months prior, and then they finally answered it after several months and stuff like that. That's waiver of sovereign immunity. You know what I mean? And think about it. All these lawsuits that are pending against these multiple entities, bro, they gang up, bro. They gonna play every dirty trick in the book, and like, not just these officers and these entities, they got family members and friends and people that are that have pending cases against them. They will put them to work, and they'll try to do something to the plaintiff, try to set the plaintiff up any way, any means possible, by any means necessary to stop this from going to trial. You know what I mean? Even with the process servers. The process server is the one who serves the summons to the defendants in the case. And even prior, the plaintiff had filed with the sheriff's office, and they can't follow. They can't serve themselves with a summons, but they took the funds anyway. That's another lawsuit in itself. This is just all stuff that doesn't have to do with any type of physical force. Just with the paperwork alone and the stuff that they've been doing. And the only benefit that I see, or the only person that I see that is not with the tomfoolery, I'm gonna say something else, is this person right here. And this is the judge presiding over the case. She has the case with the city of Lovejoy, she has the case with the city of Hampton, she has the case with Henry County, and she has the case with the state of Georgia. She took herself off the case with the state of Georgia because she used to be a district attorney or something like that. And she was a district attorney, and a solicitor, and they can, if the case is won in the favor of the plaintiff, then the defendants can file an appeal and say that the judge was biased because she used to work as a solicitor or whatever. So I mean, it's just a bunch of madness, bro. And these people are just doing all type of outrageous shit, and excuse my language. And it's frustrating. It's frustrating because you gotta think, you put yourself in this situation. You would have to sit down and learn all this on your own, and nobody's there to help you. Your family's getting paid off. Your friends are non-existent. They down with it too. They getting paid to try to screw you over. Then these law enforcement agencies, they have people that are facing charges. They can send them, which they do it all the time. They will send them to try to set you up or do something to you, because there's certain things that they can't. Well, they do it anyway. There's certain things that they can't do and really get away with it. And then this thing called plausible deniability, they could have some citizen or somebody that's facing some time. They could let them out on bond, or just let them out free anyway. They do crap like this all the time. Trust me when I say this. And send them at you to go do something with females, depending upon your gender. You know what I'm saying? Females and males, let's send somebody at you to try to get in a relationship with you, to see what you know, or try to sabotage you, plant some drugs on you, plant any, just all type of stuff. You know what I mean? That you have to look out for if you're especially if you're in the right. And that's the thing. If everything that's being presented to you right now, just that alone with the Open Records Act, this is just all paperwork stuff. With that right there alone, that's showing you guys, bro, this something's not right. You see what I'm saying? And this is for real an insurance policy, because if something was to go wrong or something goes sideways and stuff like that, and a certain individual reacts in a certain type of way, you know what I'm saying, spazzes out on one of these folks because they've been trying to do some dirty stuff, you know what I'm saying? Would the plaintiff be wrong? Because there's a whole bunch of stuff that needs to be brought to light and can't really, excuse me. I'm super frustrated, you guys. You have no idea. But I just want to say, man, thank you guys for watching. And there's so much more, bro. And it's hard. I'm going to tell you, it's hard. It's not impossible. It's just... I don't even know how to put it in words, bro. Vexing. Extremely vexing to have to fight against these people, and like your friends and family. Let's talk about family for a second. Imagine if you were related to the plaintiff and you know that he's right or she's right, and they're showing you like, look, this, that, and third, look, this is how much we can get, you know what I'm saying? Really him, but or her, but you know what I'm saying? Wouldn't you want to like help this person? Wouldn't you want to be nice to this person? Unless you got a hand in it too, you see what I'm saying? And then if everything goes south, they going down with the ship too. You think these law enforcement officers, they ain't gonna throw other people, other citizens under the bus to get a time cut? That's what people they're missing, bro. And I'm gonna tell you like that, I seen the shit firsthand. I seen officers get jammed up, dirty cops and stuff like that back in the day. I've seen people incarcerated like tell them to get their own mama and daddy set up. You know what I'm saying? Because they didn't want to go do no time, but they were right there doing the dirt with them. It's always like that, bro, when it comes to doing stuff you ain't got no business doing. Whenever folks get caught up in some stuff, they gonna tell it, bro. It's very far in between that actually stay solid. You know, they know what they signed up for and they just gonna rock out with it. People, they ain't built like that no more. You know what I'm saying? Let me go ahead and cut this short. I don't want to get ghetto and get belligerent on here, but I get so frustrated sometimes, bro. Just imagine you having to read over all this stuff. And thank you for watching, man. I hope I catch you guys in the next one, bro. I'm out.